The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome, counsel, and welcome to all those who are watching us today through our Supreme Court Live channel. Before we begin the morning docket, I do want to take a moment to acknowledge that this week we have our new colleague, Justice KJ Wall, sitting with the court for the first time. We are excited to begin this new period in our history with him sitting with us. As many of you probably also know, we will soon have another open position on the court due to the impending retirement of Justice Carol Beyer, which is effective the Friday of this week. Because of that close date, Justice Beyer is not participating in this week's arguments. We are fortunate to have Senior Judge Mike Ward participating in all of the arguments this week. Judge Ward, I'm promoting him, has sat with us since March of this year as our senior judge assigned to our court. Before that, he was a district court judge in the 13th Judicial District, which is made up of Butler, Greenwood, and Elk counties. As I mentioned, Judge Ward will be participating all week when we have a judge sitting with us on temporary assignment to the court. They do participate in the arguments, read all of the briefs, participate in the deliberations, and follow through the decision being filed in the case. So with that, move forward, counsel, to let you know we do look forward to your arguments. And I will now ask the clerk of the appellate court, Mr. Doug Shima, to please call this morning's case.
Thank you, Your Honor. May it please the court. The 9 a.m. docket for Tuesday, September 15th, 2020 consists of one case. Appeal number 111447, State of Kansas versus Victor Valdiviezo-Martinez, Johnson County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please state your appearance for the record and identify the party you represent?
Your Honor, my name is Randall Hodgkinson. I'm representing Victor Valdiviezo-Martinez, and I'm ready for argument.
Madam Chief Justice, and may it please the court, I'm Jacob Gonteski. I represent the plaintiff in this case, the appellee, the state of Kansas. I'm present and ready for argument.
Thank you, counsel. Mr. Hodgkinson, you're welcome to begin.
Thank you, Your Honor. This case involves an identity theft conviction out of Johnson County. The facts very briefly are that my client was involved in a fender bender in Johnson County at some point, and the police came along to assist and gathered some information and noticed that my client had a Nick and Jake's hat in his car. And then subsequently, there's no criminal activity or tickets or anything like that, but subsequently officers contacted Nick and Jake's to get Mr. Valdiviezo-Martinez employment information, including his W-4, and learned that Mr. Valdiviezo-Martinez had used a purchased or obtained Social Security number that belonged to a man from Washington State on that employment application in 2005. Mr. Valdiviezo-Martinez had been working at Nick and Jake's for approximately 7 years, and the employers, supervisors at Nick and Jake's said that he had never taken anything that he didn't earn from Nick and Jake's. He never took anything from any employees, but Mr. Valdiviezo-Martinez was prosecuted as part of what we know. I mean, we've seen many of these cases where the authorities in Johnson County prosecuted undocumented persons who got employment in Johnson County. So interestingly, this case was set for argument before this court 3 years to the date today. But then this court set argument aside while we had some other issues resolved, and the United States Supreme Court this last year resolved in Kansas v. Garcia and reverse this court's holding that this kind of prosecution was impliedly or explicitly preempted by federal immigration law. I think it's important to note that part of why the United States Supreme Court did that was the state's urging that these prosecutions had nothing to do with employment authorization. They had to do with filling out false tax forms. And so, for example, in Mr. VALDIVIEZO-MARTINEZ case, the filling out of the W-4 in this case. So the remaining question is this question that has split the Court of Appeals in different panels, which has to do with whether or not a situation like this is identity theft, where a person has gotten employment but has engaged in no fraud or otherwise obtained any property to which they are not entitled. So we can think about identity theft. I mean, many of us probably have even suffered from identity theft. I've had a credit card number used to buy gas or other things at different places. And we know that there are, right now, for example, dearth of unemployment fraud cases where people are using other person's information to obtain unemployment benefits. But in all those cases, somebody's getting something that they're not entitled to. And that's what the distinction is in this case. And it was the distinction between the Court of Appeals panels in Vargas and in Meza. In Vargas, the court recognized that the defendant in that case did not obtain anything that he wasn't entitled to. He worked for every dollar that he got from that company, and he didn't steal anything from them.
What if we back up, though, to the moment of being offered employment? Because I do believe the employer testified that had there not been a Social Security number, that could be that the employment would not have been offered. That's right. Although I just want to remind you that has to be severed from any idea of employment authorization, to the extent that that was because that person wouldn't have been authorized under immigration law to be employed. That can't be a part of this equation, according to what the state argued to the United States Supreme Court. But in any case, it relies then on this definition of intent to defraud, which has remained constant over the long time that we've been dealing with this, which is an intention to deceive another person and to induce such person in reliance upon such deception to assume, create, transfer, alter, or terminate a right, obligation, or power with reference to property. Now, there's been some discussion among Court of Appeals panels about whether that with reference to property is actually still a part of the definition with regard to identity theft. But regardless, the question then is, when Nick and Jake's restaurant in this case said, you can come work for us, did that assume, create, transfer, alter, or terminate a right, obligation, or power? And I would argue that there's nothing that shows that to be the case here, that Mr. VALDIVIEZO-MARTINEZ was not going to get anything from Nick and Jake's until he worked for them, and that he only received pay for the work that he did for them, that he was an employee at will. If he had shown up the first day and they said, you know what, it turns out we have enough people and we don't need you here, then he would have had no recourse. He had no sort of right, obligation, or power that he had gained by them saying you could be employed. Once he worked there and earned money, he had a right, obligation, or power, but there's no showing that the use of the Social Security number is tied to that earning the money. They're completely separate. That's why, for example, in this case, Your Honor, I don't think there's any restitution claim. There's no claim on behalf of Nick and Jake's that we want all of our money back that we paid this person. Like I would if somebody used my credit card number or got unemployment benefits. Unemployment wants their money back. But Nick and Jake's doesn't want their money back because, as it was testified at the trial in this case, nothing was stolen from Nick and Jake's. He earned every dollar that he got from Nick and Jake's. So the fact that he used this number in the employment process, I guess, not employment authorization, that there's some nuanced difference there, wasn't what caused him to get money in this case. What caused him to get money in this case was the fact that he worked for Nick and Jake's for 7 years.
Counsel, is Nick and Jake's the only conceivable victim of fraud in this case?
Not the only conceivable victim, but you would have to, it's not triggered on like and the statutes have made this clear. I think the legislature's made this clear over time that there doesn't even have to be a true victim, right? That it just has to cause some person or some entity to take some action. And so
I'm just wondering, for example, if the hypothetical person who did not get your client's job would be considered a person who was defrauded.
I mean, I don't think the statute bears out that sort of construction, Your Honor. I mean,
Well, it says any person.
I mean, no other person has a legal right to that job such that by my client, I mean, that's like people talking about admission at colleges or things like, I mean, it's a separate issue. The question is, by using that social security number, is there a connection between that, a sufficiently direct connection between that and getting pay? And our argument and what the Court of Appeals said in Vargas was no, he earned all the money that he got, unlike what we think of in typical identity theft cases.
But don't you have to be authorized to receive payment? Every time he received a payment, didn't the employer assume that he was authorized to receive the compensation based upon him being eligible to receive it? I mean, had the condition been known to the employer that he was utilizing a different social security number, would he have been authorized to receive it? I mean,
Your Honor, it can't be about authorization because the state argued successfully to the United States Supreme Court that this isn't about work authorization. There's no showing that there's any connection between the using of that social security number and getting paid. Why did Mr. Valdiviezo-Martinez get money from Nick and Jake's? Because he worked at Nick and Jake's for 7 years.
But the employer also had an ongoing obligation to pay whatever taxes were related to that employment. And that was done through reporting to the IRS. And the part of the evidence in the case was the forms necessary for that IRS tax flow, each of the steps of that tax process. So and that was done, I believe this was every 2 weeks or whatever basis, continuing up to the accident. So can you speak to that and why that isn't part of the intent to defraud by having received those ongoing tax payments and employment benefits?
Sure, Your Honor. And I think, and you talk about conceivable victims, I mean, especially because the state in this case has averred that the purpose of the W-4 here is to get correct tax withholding. That's its purpose. And so, for example, if you could show that Mr. Valdiviezo-Martinez put this fake number on there in a way to cause him to underreport taxes or some way to have not paid enough taxes, then maybe you could show that there's a connection between that on that W-4 that he intended to not pay taxes. There's no showing that Mr. Valdiviezo-Martinez had not enough taxes withheld. In fact, to some extent, it's more likely that he doesn't have the ability to get a tax refund or anything like that. There's no showing in this case that not enough taxes were withheld from Mr. Valdiviezo-Martinez wages. Your Honor, my time's really short, and I really wanted to talk to the second issue, which assumes that everything I said is wrong so far. But the consequence of that is that you will have uncoupled sort of the mens rea and the actus reus in this case. And you would have said that it doesn't matter. And in fact, that's really the state's primary argument here, is that we don't even have to show that Mr. Valdiviezo-Martinez got any benefits. We just have to show that he intended to get those benefits. And Your Honor, if that's the case, then that offense was complete. So assuming that the state, everything they say is true, that just putting this number on there with the intent to get employment is enough to commit this crime, that crime was committed in 2005. And there's no reason, because there's no showing, no requirement that he continued to receive any benefits. So long as he intended at that time in 2005, then that offense was completed and the statute of limitations ran on this case many years ago. And so, yes.
When is the crime completed under the means of using under the statute?
when you used it, when in the state's allegation here, when he put that, and the state's allegation was he put it on the W-4, that was done in 2005. And if he had the required intent and you construe the statute to allow intent for any reason, the expansive reading that the state wants, that was done in 2005, Your Honor. So for these reasons, we would ask that even in this situation, you would find that the statutory requirements for identity theft were not met in this case, and reverse. Thank you.
Are there other questions? Okay, thank you, Mr. Hodgkinson.
It looks like Judge Ward has a question, Your Honor.
Let me
Yes,
unmute
I'm
here.
sorry.
There we go. So one of your points is that no benefit was received by your client.
That no benefit was received by my client as a direct result of putting the Social Security number on the W-4.
But for the false Social Security number, he doesn't get the job. Actually, it was a real Social Security number that he wasn't entitled to use. But for him doing that, he doesn't get the job. But for the job, he doesn't get paid. How is the job not a benefit?
It's the idea, or my argument is that there has to be a direct connection, not just a but-for sort of causation, but an actual causation between the actus reus, and the mens rea, the intent to deceive. There's no showing that my client ever intended to steal anything from Nick and Jake's, that he ever intended to not work and get paid. There's no showing of that ever in this case. And our argument is that there should be some connection between that actus reus and the mens rea in this case. And the state's argument is asking you to sever that connection.
Okay. Thank you.
Thank you, Your Honor.
Any other questions? Okay, thank you, Mr. Hodgkinson. Mr. Gonteski?
Thank you, Madam Chief Justice, and may it please the court. I'm Jacob Gonteski. I represent the plaintiff, the appellee in this case, the state of Kansas. The state was not required to show that Mr. Valdiviezo-Martinez obtained the payment that was then owed back to the company, or that any restitution was owed in this case. That's not an element of identity theft. The element of identity theft at issue that Mr. Hodgkinson has taken issue with is the element of intent to defraud. And that element was proven in this case. It was proven through a string of witnesses that testified that this defendant used the Social Security number rightfully possessed and assigned to a different individual when he obtained and maintained his employment at Nick and Jake's. The testimony from Kevin Timmons, the owner of that restaurant, was abundantly clear that he relied upon the defendant's use of that number to employ him and to maintain his employment for the duration of that 7 years. Left out of Mr. Hodgkinson's argument about the 2005 W-4 is that the state also admitted a W-2 from 2011 showing that number was used continuously during the employment. And that number Mr. Timmons testified to was the same number under which the defendant was paid for the duration of his employment, including 2012, the period under which the state charged this defendant with this offense. The state doesn't need to prove, and it's not an element of the offense, that any restitution is owed. There's any number of ways that identity theft can be completed without financial resources being expended or owed to another party. And this is just one such case.
Counsel, isn't it significant that the W-2 was not prepared by the defendant, it was prepared by the employer? Can you speak to that?
I can speak to that because even though the employer may have been the one to put the information on the physical form and keep the form in their possession, which is exactly what they did, that information was supplied by the defendant. The employer did not make up that number. The employer did not steal that number from Dustin in Washington State. The employer did not buy that number at a park in Kansas City, Missouri. The employer got that information from the defendant who purported it was his. And when the employer got that information from the defendant and put it on that form, that's the information that the employer was relying upon for the duration of the employment here to maintain the defendant's employment with their restaurant. That was the reliance upon which this identity theft was founded. And it was a continuing offense because His employment was maintained through the duration of that 7 years. It's a continuing offense, unlike traditional theft. Traditional theft is completed when somebody obtains another's property without authorization with an intent to never give it back. If you steal something, you complete that when all of those elements are satisfied and the offense is done. The state did not charge this defendant with possession of the number. It could have. That's one form of identity theft, possession of the number. But what the state charged instead was use of the number. Use is another way identity theft can be completed, and that's what occurred here. And that use is, yes.
Can you, my understanding of Mr. Hodgkinson's argument is that the state is not permitted to argue that the use of the number to obtain employment authorization is identity theft because of the way Garcia was handled at the US Supreme Court. And I suppose Mr. Hodgkinson can correct me if I misstated that during, but I just would like to hear your thoughts on that question.
Absolutely. The two are separate issues. The actual authorization of employment through the federal authorization system. And traditionally, a lot of employers utilize a system called E-Verify, under which they can enter a social security number that's been provided by an applicant, and they can then verify with the federal government whether or not that individual has federal work authorization. That is not at issue in this case, because that's not what happened, and that's not what the testimony was about. The testimony from Kevin Timmons of Nick and Jake's was not that he relied upon that number for the federal work authorization process so that he could satisfy the federal government. He relied upon that number for a multitude of reasons, primarily which was tax withholdings. The tax withholdings.
Just so I understand, are you suggesting that the evidence below did not indicate that the employer relied on the number to award the job in the first place?
They did, to the extent that they relied upon the representation that that number was the defendant's and it could be utilized on those tax forms. But there was no testimony below that the reliance was based upon proof of the defendant's federal work authorization. That's not what the proof was.
Let me change the facts to ask a hypothetical. Had the restaurant owner utilized the E-Verify system here, is it your position that that would no longer be identity theft?
That would not be my position. It hasn't been our position all along. We believe it still would be identity theft. But to the extent that Mr. Hodgkinson is seeking to carve out our ability to argue that point, it's irrelevant in this case. It's a red herring in this case, because that's not what the argument is in this case. The reliance in this case was not on the E-Verify system or on the federal authorization.
Why does it matter whether an employer uses E-Verify or just thinks in their head, oh, this applicant has a social security number, so obviously they're authorized to work? Why does that matter?
The distinction is just a splitting hairs one of whether or not they're federally authorized and whether or not putting that number on the tax forms will satisfy all the various government agencies that are going to be utilizing a W-2 and a W-4.
Well, I agree with you that we're splitting these hairs quite finely, but that's the reason for my question. It seems to me that, in fact, the reason this case was brought is that it was about job authorization. And so I'm asking you to help me understand or convince me, why does it matter what the specific steps that were taken by the employer were in order to be convinced, be defrauded, essentially be deceived into thinking that the individual who had applied for the job was in fact authorized to be extended an offer of employment?
And I'm telling you, the splitting of those hairs is not necessary. And the finer distinctions as to precisely what steps the employer took to verify that or not are not relevant. But
okay, but Mr. Hodgkinson has suggested that employment authorization is not identity theft because the state took the position took that position in front of the US Supreme Court.
Correct.
And that's what I'm asking you about. Did the state in fact say that?
The state did not explicitly say as much. What the state said in Garcia was that this was more than just reliance upon federal work authorization. This was reliance upon the use of that number for a multitude of reasons, including state and federal tax forms. In Garcia, state tax forms and federal tax forms were at issue aside from the job application itself.
So the argument in Garcia was really about preemption and what use of the information might be preempted by federal immigration law, which is easy.
Precisely.
But your position would be that has nothing to do with the element of fraud with respect to how the number's used.
Correct. And I would also point out for this court that that's never been an argument in this case. That's not an argument in this case. When you look through the issues on appeal and the issues that were granted on this case, on this petition for review, that is not one of them. The preemption argument isn't here. What is here is the intent to defraud, which was abundantly clear. I'm happy to.
Go ahead. I'm sorry.
No, I'd welcome it.
I'm not sure if you finished your answer. I'm sorry.
No, that all I was going to say is, to the extent that the intent to defraud issue has been discussed at length, I'd like to be able to touch on the continuing offense and the vagueness arguments with what time I have remaining. But before that, I'd like to answer any questions.
Well, can we just break this down to the elements and tell me exactly what you would be relying on for the actus reus of use?
Yes, for the actus reus of use, it was Mr. Valdiviezo-Martinez's use of that number when he put that number on a form and he used that number throughout the duration of his employment. That number appeared on his W-4 when he filled it out in 2005 and on his W-2s, which tracked his earnings throughout the duration of employment. A W-2 was admitted from 2011, and Mr. Timmons, Kevin Timmons, the employer in this case, was specifically asked whether or not he relied upon the defendant's representation that number was his, to which he said yes, and whether or not he relied upon the defendant's representation that that number was his throughout the duration of his employment. It wasn't simply that allowed, it wasn't as though the use of the number in 2005 was simply a gatekeeping function, and then the defendant was allowed in and it didn't matter what he did after that. That's not the case. That number was still the number under which he was earning wages throughout the duration. So he continued to use the number for the duration of his employment. Kevin
So
Timmons,
the actus reus doesn't require a physical act after, I mean, the physical act that you're relying on happened in 2005. Is that correct?
The providing of that number upon the employment offer absolutely occurred in 2005.
And so from that point on, then we look at a definition of use as basically an effect or a continuation of impact by having done the act in 2005. Fair?
That's fair, but there's also more to use than just that that express event that occurred in 2005. When you look through the Black's Law Dictionary definition of use, essentially it talks about employing or putting into a function that, I'm trying to not use the word use, but putting into function or employing or putting into work a value or a number or whatever it is that's at issue here. Here, the state didn't charge possession. The state had no proof that he physically possessed that number on him in 2012, but he was still nevertheless using that number for the duration, just as if he had put somebody else's name on the application and he maintained that name throughout the duration of his employment. If he had used your name for employment to become employed and he maintained his employment that entire time, utilizing your name, he would be using the name the entire time. He didn't simply use it to gain the job through the gate. He used the number for the duration. That's why it's a continuing offense. That's what separates this, merging into issue 2. That's what separates this from a singular event that would be at issue in something like a traditional theft. An identity. Yes.
And then, I'm sorry, go ahead.
No, go ahead.
Following up there, because I want to move to a different element and kind of parse through. So if this is continuing, Justice Wall, go ahead.
I just wanted to clarify, though, that there's only one physical actus reus in that explanation, correct?
There is only one physical, correct.
So looking at the intent to defraud, who did he intend to defraud at that point?
In this case,
Nick and Jay?
he intended to defraud a pair of people at least, if not multiple. He could have intended to defraud Nick and Jake's into supplying him with all those wages and the other benefits that come with employment. State v. Mesa, the Court of Appeals opinion from 13 years ago, expounded upon all the various benefits of employment, including ERISA protections and unemployment benefits and workers' compensation and so on. It's more than just the wages. So he intended to defraud Nick and Jake's. He intended to defraud Dustin, a 23-year-old man from Snohomish, Washington, whose number this actually was. And he intended to defraud all the individuals that would rely upon his W-4 and the subsequent W-2s, which would be all the various state and federal tax agencies that relied upon those, assigned those wages to him. They assigned those wages to Dustin of Washington, not to this defendant. All of those individuals were defrauded in this sense. There was testimony from as much from the agent who testified from the Social Security Administration.
And those things you've just listed, then I take would be how you would describe the element of property benefit, whatever permutation of the statute we're looking at, economic benefit or any benefit or property.
Absolutely. And the statute was amended years and years before this offense to require no longer an economic benefit, but for any benefit. But the state has argued throughout the duration of this case that it's satisfied under either scenario, economic benefit or otherwise.
And having taken so much time on that, go ahead, Justice.
Oh, just real quick. Just factually at trial, did you show that Dustin or the person who the card, his Social Security number was tied to, was actually impacted by this, or was that just supposition?
It was supposition testified to from the Social Security Administration.
So there was no direct evidence that the consequence that you just spoke about actually occurred?
Correct.
Okay, thank you.
The testimony was about the intent and how that intent to defraud could have impacted the victim.
Okay, thank you.
Yes. I'd like to point out.
I was going to say, since I took so much time, I do want to give you time to discuss anything else on the continuing offense. So.
Thank you very much, Chief Justice. What I'd like to point out very briefly with what limited time I have remaining is both on the continuing offense and the intent to defraud factors. State v. Mesa is a 2013 published Court of Appeals opinion that talked about those arguments and found that this was a continuing offense and that obtaining employment was precisely the type of intent to defraud that satisfies the identity theft statute. As for it being a continuing offense, State v. Mesa said as much in 2007. In the 13 years since then, our legislature has done nothing to amend the statute, nothing to apprise the courts that they have a mistaken impression or otherwise. And when the legislature fails to act to change a judicial interpretation of a statute such as this one, this court should assume that the legislature has adopted that or has otherwise blessed that judicial understanding of what the statute is. That was the error in Judge Atchison's dissent in the court below, when the court below found that this was not a continuing offense and likened it more to a traditional theft and talked about how use is a single event and possession is ongoing and so on. What was missed in Judge Atchison's dissent, respectfully, was that this has been a continuing offense since at least 2007, when the Court of Appeals said as much, and the legislature failed to rectify that if that was some sort of error. On the vagueness argument, I believe that was fully briefed by both sides. On any of these issues, I would welcome any questions the court may have. I don't want to run over my time any more than I already have, but I'm asking you to affirm the Court of Appeals decision below. The state also offered a 609 letter a couple of weeks ago recounting other cases which have had similar outcomes from the lower courts in this case. I'm asking you to affirm as much and affirm this conviction.
Other questions?
Yeah. Counsel, let me tell you what I'm having trouble with. I think you've conceded that the only thing that the defendant did, he did in 2005 in terms of an act, some act. The rest of your case is that he didn't correct the impression that was left from that 2005 act. So I take that and I apply our case law that says that in order to have a continuing offense, we need explicit language in the criminal statute that compels the conclusion that it's continuing. And when we're running over to Black's Law Dictionary, which has several different definitions of use, you've given one. How do I get comfortable with the requirement that the statutory language has to be explicit under your theory of the case?
I believe you can get past that because in this case, use implies an ongoing event, not a singular in time, not a down to a second precise event. That could be a possession. An individual can be found in possession of a stolen item or of some other drug paraphernalia, for instance, and so on. A possession can be singular. Use can either be singular or it can be ongoing. But I would also point the court to 2C versus United States, which was in the state's brief in this case in talking about continuing offenses. Statutes should be considered continuing offenses if, as you stated, Justice Biles, there's explicit language in the substantive criminal statute. Or there's another way that it can be found to be a continuing offense, and that is if the nature of the crime is that the legislature must assuredly have intended to be a continuing one. This is precisely such a scenario. When you go through the identity theft statute, the gravamen of identity theft is not simply obtaining or knowing or having somebody else's personal identifying information. I have the names of all the parties in this meeting today. I don't have an intent to defraud anyone with that, but I have that information. Simply having that information or possessing it is not the gravamen of identity theft. It's the use of it. It's the employment of it. It's deploying that information in a fraudulent way. That's why identity theft is a felony. That's why the Kansas legislature has taken it as seriously as it has, because employing or deploying that information in a manner whereby somebody is defrauded with an intent to obtain a benefit for oneself, that's the gravamen of the offense. That's the harm. And that harm is an ongoing and lasting one. It's not a pinpoint in time. Traditionally, identity theft, if somebody else's personal identifying information is used fraudulently, the harm is not singular and it's not pinpointed. It's an ongoing one. It's harm that has been expounded upon by lower courts addressing this very issue in Mesa and other cases. That's why the legislature takes this offense as seriously as it does, is because it's not a pinpoint in time. It's an ongoing one. So the state would argue that to the extent that you're struggling with finding explicit terms within the identity theft statute as showing or evincing intent to create a continuing offense, which I still maintain the statute does, to the extent that that gives you difficulty, then the other avenue still exists, which is a very clear one, which shows that the nature of this crime is such that the legislature clearly, assuredly intended this to be a continuing crime.
But is that language consistent with our Kansas statute in 215107F?
I believe,
you know, that the legislative purpose must be plainly appear. Does that mean an explicit statement?
I don't believe that requires explicit words within the statute to state this offense may be a continuing one, but it needs to be plainly clear to the extent that the statute shows what it is that the legislature is seeking to prohibit. What the legislature was seeking to prohibit here was not the singular event of obtaining or possessing that information with ill intent, because that's not the gravamen of the offense. The harm with which the legislature was seeking to prohibit and to diminish and to resolve was that ongoing harm that comes to a victim or any other party that's defrauded by this improper use of somebody's personal identifying information. So I believe as though it is plain within the statute that this is a continuing offense, because it should, the legislative intent is clear as to what they were seeking to prohibit. It's more than just a singular event in most cases. It can be a singular event. Hernandez Carballo showed as much. The individual that was encountered by police who had the ID of another, and Hernandez Carballo outright admitted that she was going to be using that other identity to obtain a job. That was a fixed point in time, and that could be prosecuted as such for the possession of that other identity. This case involved more than that, and it involved the use of that for a long period of time.
Other questions? Thank you, Mr. Gonteski.
Thank you.
Mr. Hodgkinson, I believe you reserve 3 minutes.
Thank you, Your Honor. And I guess I just want to sort of start where my colleague ended, which is, and I want to really make it clear that, and Justice Wallace goes to your question somehow, that, I mean, the state can't have their cake and eat it too. I mean, the state wants to say, and is saying to you today, we don't even have to prove any harm. That's not an element of this offense. That's what they've said repeatedly. In fact, if you adopt the state's view, they don't even have to show my client got the job. Under the state's view, my client is guilty of this crime when he filled out an application or used a number with the improper intent. They've made that extremely clear through all of their arguments. And if that's true, then that offense is complete. All of the elements of that offense, according to the state, are met when the actus reus and the mens rea come together. But here the state is trying to divorce those things and separate those things. And that's what we're asking you to, don't let the state have their cake and eat it too. They have to choose. Do they want harm and actual fraud to be an element of this crime? If so, there's no showing that Mr. Valdiviezo-Martinez took one thing from Nick and Jake's that he wasn't entitled to. There's no showing that Mr. Valdiviezo-Martinez got any tax benefit from filling out this W form with a different Social Security number. There's no showing of harm.
Counsel, set aside the benefit question for just a second. And I just want, I guess, your perspective on the question, was your client using the Social Security number in 2012?
No, he didn't. There's no evidence that he was filling out any forms in 2012. I mean, we can think about.
So, I'm sorry. The state has argued that its use is broader than filling out forms. You would obviously disagree with that, but I guess as a follow-up, help me understand why your client wasn't using the number when the testimony was, but for the number, he wouldn't have been able to work there.
It's because it has to do with the intent to defraud, which is defined as.
Let me just concede that maybe it wasn't with an intent to defraud. I'm just trying to zero in on use. Was your client using the number, even if it wasn't with an intent to defraud?
I mean, I think of the actus reus being the defendant has to do something. I mean, I think about even your case is talking about continuing offenses, that, just having stolen something and still having it isn't continuing to steal it. And so even if we assume and you find that putting that number on the W-4 constitutes use coupled with intent, there's no showing that that should go on forever. Or why, as Judge Assison rightly held, we think, was an event on that day. And if that was the crime on that day with the mens rea and the actus reus combined, it was completed that day, even according to the state's argument.
Thank you.
And was he possessing it?
I mean,
Jackson suggested.
I think my colleague noted, I mean, I don't think there's any evidence in this case, sort of a physical possession. And it's an interesting question, even as my colleague was talking about it, whether like just knowing it is possession, that I don't remember any case addressing, just sort of, if I've memorized some number, do I possess it? I mean, there could be a different case where somebody's charged with possession, if they had physical possession of something as an actus reus, that might be over a different period of time, but that's not what was charged in this case.
Could you briefly just address counsel's point that this case, when argued at the US Supreme Court, was on a distinct issue, preemption, and that's different than what we're confronting here?
Sure. And I mean, obviously, the best source would be to read the state's brief in the case cited by the state. I mean, they cited Davy Garcia, and you can access the briefs there. Certainly, it's our position that the state argued below that what was the benefit that he didn't get a job. And then when they went to the United States Supreme Court, they said, well, actually, this wasn't about him not getting a job, about him getting the job. It was about him filling out a tax form incorrect. It's not about authorization. I understand my colleagues and acknowledge it's a fine line. They're arguing this was about him getting a job, not him being authorized to get a job. But even if you think that and find that that's a nuanced fine line that you can adopt, certainly that was never brought up or made clear to any fact finder in this case, that we can't be considering the actual federal work authorization and really questioning, well, is the only reason that you wouldn't give him a job because he wouldn't have been federally authorized? If that's the case, then that shouldn't have been considered in this case.
There are other
That's all I
questions?
have, Your Honor.
Okay. Thank you, counsel. Counsel, we will take this matter under advisement. And we will be in recess now until 11 a.m. Thank you.